Okay, will do. We are live and on the record. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting virtually within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. We are hearing one case this morning. This is a hearing that was continued from our March sitting. The panel consists of myself and Justice John Englander, Justice Marguerite Grant. The case that we will be hearing this morning, case number 2021-P386, John Doe, number 285142 versus Sex Offender Registry Board. Each side will have 15 minutes to argue. There is no rebuttal, and we are ready to proceed. Mr. Gauthier, with your presentation.
Good morning, Mr. Chief Justice. Good morning, Justice Englander, and good morning, Justice Grant. My name is Attorney Edward Gauthier, and I'm appearing today on behalf of Plaintiff Appellant John Doe. As this panel knows, 2 years ago, it remanded the SORB case back to the hearing examiner to assess whether a public safety interest would be served by the internet dissemination of his biographical information. On remand, 3 years after the original hearing and 3 years after finding a fact, the hearing examiner applied essentially two facts to establish that the public dissemination would be warranted. One was based on testimony by Doe during examination by the hearing examiner, where he indicated that as of 2017, he was not taking prescribed medication. And the second was a statement he made 11 years prior to the hearing during the course of his offending against the victim in this case. He made a statement to a friend of the victim that could be interpreted that he was interested in her. I'd first like to address the medical testimony. The medical testimony was not provided.
Let me just stop you for a moment, because you're emphasizing the datedness of the evidence. But did the petitioner attempt to put in any additional evidence in the rehearing, which I think was in 2020?
Your Honor, the rehearing was in May of 2020, and the answer to that question is no. The petitioner did not put in any information in 2020. However, our position is the law is very clear. The board has the obligation of proving by clear and convincing evidence each of the factors. It relied on a statement by Doe in 2017 to find that in 2020, he was not taking prescribed medications. If it wanted to do that, it should have reopened the hearing where it has the burden of proof and established that.
This was remanded to address a gap in the analysis the hearing examiner conducted on the evidence taken at the 2017 hearing. And I guess as a threshold point, I'm a little skeptical of the notion that to reapply an analysis and an examination on remand of a previously entered order, it's incumbent on the hearing examiner to take new evidence.
I don't disagree that this court order did not require the board to take new evidence. However, the law and regulations are very clear that when a board issues a decision and it reissued the decision, it considered factors 33 and 34 anew. This court held that the board improperly gave less weight than it should have to factors 33 and 34, so it considered those factors. However,
the plaintiff has the. I mean, one of the things that's inherent in these cases is the plaintiff always has the opportunity to go back in and request modification or reclassification based on new information. This was in a different posture. This was designed to go back and take corrective action on a weakness in the explanation of an original order. And again, if as part of that process, the petitioner wanted to have the hearing examiner incorporate consideration, to have that avenue open to him. But I push back, I guess, on the notion that the hearing examiner had in that procedural posture an affirmative obligation to treat it as a brand new hearing.
I agree, Your Honor, that we are not saying that the hearing examiner had to treat it as a brand new hearing. Nonetheless, this is a May 2020 decision where a hearing examiner found that in May of 2020, internet dissemination is warranted.
Surely you're not suggesting that she couldn't rely on the evidence. I think it is the hearing examiner, she, I think it is, but that she couldn't rely on the evidence she took in 2017, right? I mean, unless there's something about it that indicates it self-destructs. I mean, in the sense that it's no longer going to have, purchase in 2020. Why? I mean, yes, it's more dated by 3 years, but other than that, why is it that it can't be relied on?
Because SORB hearings are a little different, I would say, than other administrative hearings. We deal with static and dynamic facts and factors. And if this was a static fact, if she made a determination of a fact in the past that was not subject to change, then yes, the fact isn't going to change. But she decided in May of 2020 that internet dissemination was appropriate based on a fact that was subject to change. And
but that decision relates back to her directive that internet dissemination should occur back in the original decision in 2017. And to the extent that there is now an implicit suggestion that intervening circumstances, intervening facts, intervening conditions should warrant a change in that, it seems to me, again, that it's incumbent on the petitioner to bring those forward, not on the hearing examiner to tease them out for a brand new determination.
well, I guess Doe and Your Honor will have to disagree on that point.
Well, if we do, then you know how that comes out.
Well, we certainly do, Your Honor. We know who makes the decision in the end.
But based on what? I'm trying to understand. So is it the law that each of the levels must be proved by clear and convincing evidence? Is that and that burden lies with SORB?
Yes, Your Honor. The board is required to prove risk of reoffense, degree of danger, and the utility of internet dissemination, all by clear and convincing evidence,
Okay.
as of the date of the decision.
Okay. So how is it that wasn't done here?
Because our position is it wasn't done as of the date of the decision. The date of the decision is very important.
But she relies on a whole number of factors, right? I mean, you started at the top saying really she was relying on two things, which were the testimony about the medical condition and the evidence of an additional entreaty to a 13-year-old. But that's not true. I mean, I read the whole opinion just about 10 minutes ago, and she talks about many other things. And I mean, we evaluate the totality of what the report says, right?
When considering a finding of clear and convincing evidence, all the evidence comes in. However, in 2020, this court found that there was no analysis of why internet dissemination would be appropriate, which is why it was remanded, and the internet dissemination was justified on the two facts that I have mentioned. There are other factors.
I guess my question is, in the posture of this kind of remand for that, to address that shortcoming in the original decision, why is it so abundantly clear, or why is it a function of the law that the decision is, while made in May of 2020, is not considered as of the time of the original decision?
Well, I can tell, it's not in the record, Your Honor, but I can tell you based on the law that a John Doe, a sex offender, is allowed to petition the board for lower level reclassification.
Yes, precisely. And that was the point I was making earlier. If he wanted to do that, he can do that. But this was not that type of a proceeding. This was a remand to address a shortcoming in the original decision. And if Doe wanted to come forward and petition for a reclassification or bring new evidence forward, that's still open to him.
In 2023, Your Honor.
And in 2020.
Well, I can tell Your Honor that that's not necessarily the board's position.
We've had this
Okay,
conversation.
but there's no record of that. Sorry.
Well, that's what I'm saying, Your Honor. It's outside the scope of this, but if Doe could re-petition in 2020, he would have.
Well, I've had this conversation actually a few times with Mr. Chennai in recent months, and we'll see. I think the board may be coming around on that point. But I hear the concern. I just think that the notion that this is a brand new decision in May of 2020, when it was directed by this court to address a shortcoming in the 2017 decision, I have difficulty viewing it as requiring the hearing examiner to conduct an entirely new hearing to assess conditions as they exist now. And I think in a rational universe, it ought to be open to the petitioner to initiate that kind of a proceeding to the extent that the board may in the past have deflected those attempts. I'm hopeful that they will reevaluate that position.
Your Honor, that's absolutely our position, Your Honor, that if this is simply a rewriting of the 2017 decision, he should be able to petition for reclass in 2020 and not wait till 2023. However, we're here because.
Got it. All right.
I have a question.
We'll hear from Mr. Chennai when we come to that.
No. Marguerite has a question.
Yeah, no, I understand.
In your brief, you have a footnote about the relationship between factor 7 and internet dissemination. And I understand it's your position that this first complaint witness that the victim apparently disclosed to also disclosed that the defendant had made advances on her. And your footnote says that where if the abuse is all intrafamilial, there's no need for internet dissemination because everyone in the family knows about it. Could you tell us a little bit more about that? What about the fact that this victim apparently has young children who might not know about the abuse at the time it's happening? And what about the possibility that there may be family members who are in denial about the abuse? Doesn't the internet dissemination serve a purpose there?
Your Honor, I would point out that in the 2020 appeals court decision, a panel of this court specifically said that there was simply lacking evidence that there were people outside of the victim who would need this. And our position is any potential victims outside of the victim in this case would be speculative. I believe that the evidence, Your Honor, clearly suggests that the victim.
Why does the victim need internet dissemination? She knows what happened to her.
Absolutely, Your Honor.
She needs to know where he is.
No, there's no contact. I believe the record is clear, Your Honor, that Mr. Doe's entire family is aware of his offending, and it would be speculation to look at this record and say that he has any contact with a potential victim pool. His own testimony was he was using drugs. It was very situational. It was a person within his home, and he offended. There's no evidence in the record to suggest that he's around people within that age group at any point at this time.
But isn't the point of internet dissemination to protect other potential victims, whether intrafamilial or extrafamilial?
That is true, Your Honor.
And there's nothing in here about where he lives or whether there are people, down the street who are of young age. There's nothing that tells us that he couldn't have that contact tomorrow.
Your Honor, I would simply point out that Doe is not required to disprove. The board is required to prove. So to speculate that there could be children in the neighborhood or contact, that's speculation, Your Honor.
Well, I'm not so sure. I mean, I understand your point, but I mean, every one of these cases that I've heard operates on the assumption that it seems to me, that this person is out in the community unless told otherwise. Because human beings, I infer that if you're a human being living in our society, you're out in the community. And you therefore have
I'm
access.
not sure that it requires a great deal of affirmative proof that there are children in the general community.
Is it your position that under factor 7, if the abuse is only intrafamilial, there's no need for internet dissemination?
Every case is a review of the totality of the circumstances. I would simply point out that it was this court 2 years ago who pointed out that the only victim was intrafamilial, and perhaps there needed to be a greater justification for internet dissemination as the circumstances between now and 11 years ago are so very different.
Yes, but if the court had viewed that as being dispositive, there would have been no reason for a remand.
Every case is a totality of the circumstances.
Right.
Okay, and I'm really struggling with I'm looking at what this court said. On remand, the examiner has full discretion to take new evidence on the factors identified in addition to any other factors as to which circumstances may have changed. No such evidence was put in, and you seem to be trying to lay that at the board's feet, and I'm struggling with that. Both parties had the opportunity to put evidence in on that subject or any of these other subjects. All right, I'm sorry.
All right, thank you, Mr. Gauthier. We'll hear from Attorney Chennai.
Thank you, Your Honor.
Thank you, Your Honors. If it pleases the court, David Chennai for the board. I think that one of the things I was going to talk about was the fact that the board would consider the reclassification date in this case to be as of October 5th, 2017, meaning this individual in the fall, in October of 2020, if he had asked to dismiss this appeal and could have had a reclass at that time.
I've alluded to our previous hearings where we've discussed this point, and I will confess that in the press of other cases and other matters, I'm a little fuzzy on the precise contours, but am I correct that there was a time when the board took the position that during one of these pending appeals, the petitioner was foreclosed from seeking reclassification based on new information?
Yes, and that was, and I think that if you remember, I think it was yourself, Chief Justice Green, that grilled me one day on that. I went back to
in July, if my memory serves me, along with Justice Milkey, and I forget who else was our third panel member.
Yes.
And that was our first return to the John Adams Courthouse for in-person arguments since the pandemic. I have a clear recollection of that encounter, and you seemed appropriately chastened by the conversation, and reported back at the next hearing that the board had considered your counsel and taken a different position. Is that correct?
Yes, Your Honor. I don't know that they consider my counsel as much as the court's counsel, but they've just, unless there's an intervening brand new hearing and it's only remanded for findings of fact or law, the board will go back to the original classification date as the date that would start the reclassification process. So in this case, it would be 2017 because we didn't have a brand new hearing on this matter. It was only an amended decision.
Can I ask you that?
The petitioner has the right to move forward on the ordinary track, but separately from that, if the hearing examiner determines to open up the hearing for new information, that can evolve into the functional equivalent of a reclassification hearing because they are taking new evidence, and they can take all of that on the remand.
That's not how the board is. In fact, this case specifically is a good example. As soon as a case is remanded for not a new hearing, but for the taking of clarifying evidence, a letter goes out to each party asking if they'd like to update the record, which was done in this case. But the board does not consider that a new hearing. They just consider that it gives the opportunity for both parties, because the appeal process can last a little bit of time, to put in any additional information. In this case, both the board was asked if we would like to put in more information, which I didn't see anything particular that we had to add. And the plaintiff in this matter was offered the chance to introduce additional evidence. The board doesn't consider that a new hearing. A new hearing for the board is when they actually conduct a hearing where both parties appear, they have testimony or the right to testimony, and the introduction of documents. So in this case would be considered to be eligible for reclass back in October of 2020, but the board is clear.
Counsel, can I interrupt? I'm sorry. I have a question about our direction is the examiner has full discretion to take new evidence. That was our direction in 2020. As of
Correct.
that time, would the board have taken the position that the petitioner could not put in new evidence?
No, in fact, the board, I believe, sent the petitioner a letter asking if they'd like to introduce evidence into this matter
Okay.
after the last appeal, and there was no evidence produced by either party. But the board, when a case is remanded to the board for reconsideration, the board always sends out a letter to both parties, giving them a period of time to introduce any further evidence that they would like to add to the analysis. The board doesn't consider that the new hearing.
Okay, all right. I got that. So let's move on for a moment then.
Sure.
What do you do about factor 2?
Well,
What is
I
the
read
position
I
of the
read this case
board?
and saw factor 2 again, and I said, oh gosh, not again.
What is the position of the board now with respect to factor 2? Factor 2 was one of many factors that is discussed in this
Right.
decision.
And factor 2 is misapplied in this decision under the board's new policies based on Justice Wilkins' decision back in 2000, back last summer. The board would, in this case, and I've said it before, would agree that it was misapplied, would only state that under the circumstances of this case, that misapplication of the factor wasn't prejudicial. If the court doesn't agree with that.
Meaning that if you
which-
excise factor 2 from the consideration, it would be the board's position that he still should be a level 2.
Correct. Now,
And that there was sufficient evidence for that?
yes, based on the analysis of the case, the type of sex offense it was, the fact that the hearing examiner had reduced it from a 3 to a 2 based on the time period that went by, the board's position is that the evidence didn't suggest that he had already, at this point in 2020, had been reduced to a 1, but had reduced to a 2. Now,
As I understand, Mr. Chennai, the board's position is not merely that the evidence is sufficient, but that the evidence is sufficiently compelling that there is no realistic prospect that the hearing examiner would do anything different if factor 2 were excised.
Yes, as of the decision in 2020. Now, if he files for a reclass, I don't know. With the passage of time, the hearing examiner really focused on the passage of time and in that period of time between the remand and the new decision, the fact that the individuals reassessing the individual's current stability and continued current stability and continued support network gave full credit to those areas, reducing the risk. Now, I'm not sure on a reclass if that would come down even further. That would be speculation. But right now, as of 2020, I think the evidence was still compelling without factor 2 to support the level 2 classification. Now, the one thing I would point out is if the court, and historically the court has not agreed because of the gravamen of factor 2, if it were to be sent back to the board, I would say it should just go back for a new hearing because he's eligible for a reclassification anyways. And we would just be spinning our wheels to send it back for reconsideration, a new decision, and then come back when the individual does have, at this point, a right for a reclass.
I mean, here the petitioner has even tomorrow before, I'm going to presume that we will not go through all of the post-production mechanics. Even if we were to write it today, it won't release tomorrow, but the petitioner could initiate a reclassification request this afternoon.
Well, unfortunately, the rule still is that reclassifications are only when the individual's has no case pending. In this case, there's a still pending case. The minute the court decides on this, or he could move to dismiss the appeal and he would immediately be eligible for a reclass, or to wait for the court's decision, and regarding what the court decides, he would then be eligible to apply for the reclass. But the law, the statute, and the regulations don't allow reclass while an open case is pending, because the theory is that hasn't been resolved, so a classification hasn't been established that you can reclass from.
I understand. It's not a jurisdictional question. It's a matter of the foundational predicate for the reclass. I get it.
Correct, Your Honor.
So can I just switch gears? What do you say to the argument that your opponent makes that the regulations really, with respect to medical issues, they want someone who's medically qualified, and here they're relying on information that came from someone who is not medically qualified?
No, it's an interesting argument, but to apply Factor 31, you look for medical evidence, correct? But in this case, this individual made statements about his medical circumstances that represented substantial evidence. In fact, they were detailed. He gave descriptions of what his situation was. And the issue on that type of evidence is whether or not the hearing examiner had the right to rely on this individual's statements about his own physical health.
Well, let me also just, my understanding is that it's not a situation where the petitioner self-diagnosed, but instead reported diagnoses by qualified professionals.
Correct. And the assumption being that he would know more than, other than having medical records, he would have the best position to determine what his medical situation was in the diagnoses he received.
I'm not sure about that. It seems to me the medical records are better evidence than his report of what the medical records say. But the point is that his report of a diagnosis by a qualified professional nonetheless is entitled to whatever evidentiary value the hearing examiner chooses to give it.
And I think the issue with the medicals really is the fact that he indicated that although told not to, he stopped taking his medications because he didn't want to take them anymore because of the adverse side effects. But he was doing it against medical advice. And clearly, at least one description he gave of one of his episodic moments from not being on medication was very concerning. And I think that the hearing examiner had the right.
Well, but that's the problem. That's the problem. So I take your argument, which I understand, but you just inserted the words that occurred from not taking his medication. Well, there's no evidence of that. We don't know why this happened. There's no expert who said this kind of episode occurs when you don't take the medications that he was supposed to be taking. And that's the risk. Okay, that's the problem with relying on a medical history without any expert testimony.
I understand your point, Your Honor. And even if that connection can't be made, it's still a concerning episode, regardless of whether it was because he wasn't.
It is, but we don't know why it happened. Correct. I mean, he yelled at a coat hanger.
Mm-hmm. And frightened his significant other at the time. But again, it's whether or not the evidence is enough for the hearing examiner to rely on it. And again, when you look at hearsay, this individual's description of his situation was very specific and very detailed. And when he was diagnosed with certain illnesses and the medical community's response to that, and his determination not to take the medication that was recommended for him. And I guess, my brief covers, I think, these issues fairly well. If the court is satisfied, I'd be more than happy to rest on my brief at this point.
Seeing no other questions, the hearing is concluded.
Thank you.
Thank you both.